Today we're going to be talking about premises liability and business protection against acts of third persons. So with holiday shopping coming right up around the corner, it tends to be a pretty dangerous time for both businesses and customers. Businesses are typically posed with the threat of liability of injured customers due to the criminal acts of third persons. So the question at hand here is, are these businesses liable for injuries sustained by customers due to the criminal acts of an unknown third person? This is a question that's pretty prevalent on everyone's mind with the Ferguson riots that have just happened, especially for owners like those who owned this Quick Trip in Missouri. Are these businesses liable, say, for people who were standing around and maybe got burned, or even trampled by rioters, or even experienced emotional harassment by the incidents that occurred on the premises of the Quick Trip? Holiday crime is a pretty big area here too. Crime in shopping areas always increases during holiday season, and businesses are always having to take extra precaution to ensure the safety of customers, especially in parking lots, due to the number of assaults that increase and the lack of security. So premises liability, the definition of that is that businesses open for public entry for business purposes. In other words, when people come onto the public property of a business for the purpose of benefiting that business, the business becomes subject to liability for physical harm caused by accidental, negligent, or intentionally harmful acts of third persons. Factors of premises liability include relative degrees of care, which is just a higher degree of care than negligent claims, and then defect or dangerous conditions known by the business owners, known to be on the property and to be dangerous. But negligence and protection acts against acts of third persons. The general rule is that businesses do not owe a duty to protect their invitees from criminal activity. Of course, exceptions are always there, and the exceptions to that general rule is the indication of danger, whether it's foreseeable. If it's foreseeable that a crime could occur, or if there's a person that comes along and they seem to be quote unquote sketchy, or they tend to, or they've been known to engage in criminal activity before. Williams v. Barnes and Noble in 2005. A customer actually sustained injuries after being pushed down by a shoplifter who was being chased out of the bookstore by an employee. Now, the premises liability claims were not supported because the employee's negligent acts were not a dangerous condition of the actual premises or property. Typically, a premises liability claim is going to be a negligence claim against the property. But for the protection against acts of third persons, foreseeability is always going to come into play. There was no reason to foresee that a shoplifter would knock her down after being chased by an employee. So the special circumstance and special relationship test that comes along with the premises liability and protection against acts of third parties are always tests that are used. The special circumstances test typically deals with past incidences of crimes and past incidences of things that are happening currently that have already happened before. Special and things that the business should have taken note of. Special relationships completely depends upon the position of parties, whether the party depends on the other party for protection, such as an innkeeper and a guest, a carrier and a passenger, business inviter and invitee, which we've been focusing on mostly here, voluntary custodian and protectee. In the case Stafford versus Drury Inns in 2005, Stafford sustained injuries after two men came up to his door, which supposedly had no peephole, and there were also no key accesses to elevators. These two men came in, beat him up, and then Stafford filed claims against Drury Inns, and Drury Inns was actually found, they ruled in favor of Stafford because Drury Inns, since Stafford was a guest and Drury was the innkeeper had a duty to protect his guest. So does all of this apply to off-duty employees? Negligence does not apply in the case of off-duty employees. Reasonable precautions to protect customer from risk of bodily harm by off-duty employees on the premises falls directly on the business. They are in charge of their employees at all times. There is no need to prove foreseeability in the cases of off-duty employees, only that injuries could be reasonably expected from defendant's negligence. Foradori versus Harrison in 2008 had to do with a teenager who was eating in a Captain D's restaurant when Harris, another older teenager, started picking a fight with him based on he was hitting on his girlfriend. So Harris picked a fight with him, and the manager of the Captain D's restaurant ordered them to take it outside. So when they took it outside, there were 2 or 3 other much larger, older teenagers who joined the fight. Harris was not the first person to do this. Al Cannon was the one who actually asked him to fight. And so when they went out into the parking lot, Harris was a much larger man, or much larger teenager, who also worked at Captain D's. He clocked out before walking outside, and while in the parking lot, he made a running start and full force punched Foradori in the back of the neck, permanently paralyzing him, making him quadriplegic from the neck down. So Foradori was actually awarded $10 million to this suit, saying that the business was negligent due to the fact that they allowed, that they could see that it was going to get ugly, and then the manager sent them outside. So now we're into the analysis of scholarly things section. So merchants' duty to protect invitees from third-party criminal acts. This is a Campbell, North Carolina law review. And basically what it said was fairness of holding business owners responsible, because it's not fair to hold these business owners responsible for the acts of third parties, because the acts of third parties are completely unpredictable and unreliable. In North Carolina, they have a flow of injury, and since the flow of injury didn't come directly from the business, they cannot be held liable. Liability for visitor injuries on premises as a result of foreseeable hazards created by third parties. Some of these cases are Foster v. Winston-Salem Joint Venture, Long v. National Food Stores Incorporated, Ward v. Southern Railways Company. That one was especially interesting. It had to do with railway employees being killed as other railway employees on traveling cars, and thieves would throw pieces of coal at them and it would kill them. And then Azer versus the city of Charlotte, who actually sustained injuries from a hockey puck. Business owners' duty to protect patrons from criminal acts of third parties. This is a Louisiana law review, and this law review actually stated that businesses are responsible, in fact, for third-party crime against patrons, because third-party crime against patrons is foreseeable and is expected. We expect to see crime and we expect to see shoplifting. And so businesses should take precautions, installing security guards and emergency call boxes, lighting, etc. Business owners have a responsibility to protect their patrons, since the patrons are coming and benefiting the business. So premises liability risks expanded in Missouri, and this is a law review of that expansion. So the legal insurance and security costs were too high for many 24/7 convenience stores, and many of these stores had to close up shop because they could no longer afford the costs because of the use of a broader foreseeability test versus a narrower foreseeability test. In a broader foreseeability test, the plaintiff typically can take their determination of fault all the way into the jury room without it being dismissed on certain grounds. Versus a narrow one, typically they can be thrown out on certain grounds if there's not enough evidence. So the overarching issue that I could find here was that criminal acts by third persons are expected and foreseeable. This is why we train our employees to not chase people, even though someone did in Williams v. Barnes and Noble in 2005. People are always going to do what they think is right, but most importantly, employees are trained in a way to know and to expect third-person crimes. But the extent of the injuries suffered by patrons are not foreseeable. Especially in Foradori v. Harris, how could they have possibly known when sending them outside that this kid was going to be quadriplegic for the rest of his life from the neck down? So the overall is that businesses should take precautions to prevent crime, but should not be held liable for crimes committed by third persons that result in unforeseeable injuries suffered by a patron. Overall, people are going to do really dumb things. And in summary, liability of third-party criminal act, the general rule is that there is no duty owed, with the exception of special relationship and special circumstances. Foreseeability of the criminal act is a factor in judging whether or not the liability of the third-party criminal act is there. Defenses against liability for a third-party criminal act is no special relationship, foreseeability, proximate cause, and no duty resulting from public policy concern. Proximate cause is also a defense. The premises liability is a negligence charge. The exceptions for that is defect or dangerous conditions, condition of property, not negligent act of employee. Relative degrees of care are also part of the factors of premises liability because people do dumb things.